Good evening to me. I didn't publish or publicize this, so I have no idea if other than I will be watching. Whoever's there, that's great. I was figuring I was going to post this like a video. So if nobody showed up, then that's cool. But whoever shows up, greetings and salutations to you out there. Glad to have you on board. I just decided I wanted to do a video and I was going to address both GTII and a little MMTLP tonight to add a nice little flavor to it. I'm going to babble a couple minutes, let a few people come on board. Hope everybody is well. Hi Barefoot. Who's that else do I see? I see Techna Schlega. I like that. It's funny. I was where was I? I was in Baltimore earlier this week. It was colder than LA. Where we were was a nice area, and then I went to a wedding. And it was all good. So I'm back babbling. Just let a few more people join in. I'm going to get started. What I want to do is going to talk a little bit about this is not legal advice, obviously, and this is not legal advice, realistically. But this really is not legal advice. It's just opinions and just nonsense and talking, except where I say it's otherwise. Like if I say I know something, that means I know something, not that somebody told me. Usually I will have firsthand knowledge, like I will have seen a document, for example, or something, which will be relevant when I get to it in a second. But before we go in there quickly, there was a local glass blower who inhaled while he was I have to set this up a little bit. So my stomach's off. I've had a bad stomach. Got to let you in on that. I've had a bad stomach for a while, on and off. It's the way it goes. So a lot of these so-called jokes tonight are related to bad stomachs. So I'll give you a little context. All right. I saw this in the newspaper this morning. The local glass blower in my neighborhood, he inhaled while he was working. He ended up with a pain in the stomach. Yes. And speaking of that, whatever that is, when making stomach puns, it's best to go with your gut. And what's the real definition of surprise? Gas plus a little extra, if you know what I'm saying. And last but not least, actually, before I get to the last but not least, if there's any Canadians watching this tonight or at some other time, because you might be watching it at some other time, I was thinking about the movie Down and Out in Beverly Hills. Seen that before. I'm sure a lot of you have seen it, at least at some point. If you're Canadian, you would say Down and Out in Beverly Hills. Isn't that correct? And last but not least, if that's possible, as I was setting this up today, I happened to come across another video, and the headline or the thumbnail said, and I was crazy about this. I thought it was a terrible, terrible outcome. It said, "New members exploding." I think that would be terrible if that was actually happening, but that's what it said on his thumbnail. So I hope those people are okay, because if you explode, probably is not. You don't end up in really good shape most of the time. Most of the time. So as I said, if I say I have personal knowledge about something, that means excuse me. If I say I know something as opposed to I've heard or I'm speculating, whatever, that usually means, more than usually, that means I have personal knowledge. So we're going to talk about a few things. One, I'm going to get to MMTLP will be our last thing. So if you're an MMTLP fan, hang out, come around. First, I wanted to talk about why. So now I'm going on GTII. Why has the FBI and the SEC not arrested any of the people that should be arrested? Those people, I think this is a common belief, right? If the receiver's reports are accurate, and we have no reason to suspect they're not accurate or mostly accurate, maybe there's some stuff in there we would think that probably shouldn't be in there, but mostly they're accurate. But why is no one in jail if the receiver's reports are accurate? Why has nobody been indicted? As far as I know, nobody's been indicted. But if the receiver's reports are accurate, then obviously there's all kinds of misconduct that arguably could be criminal misconduct, arguably, that's been asserted by the receiver. And if that, and I mentioned that deposition when there was an issue about money laundering, that Dylan, in questioning the witness, he seemed to conclude that the witness's testimony kind of suggested money laundering, amongst other things. There was no, obviously, no trial and no conclusion, but that's kind of what he, more than what he suggested. I think that's what he said, at least in private. So with that all known, beyond that, I know the FBI and the SEC know about GTII. How do I know that they know about GTII? Because I've seen documents that were sent to the SEC and the FBI related to GTII. So if I've seen documents that were going to the FBI and the SEC, I think I can feel comfortable that the SEC and the FBI know or should have known. And I think some of those documents were sent more than once. So I presume the FBI and the SEC know or should know. So that being the case, and with the receiver's reports, why are we sitting here today, January 8th, 2026, 6:21 p.m. Pacific time, by the way? Why are we sitting here today and there's been no indictments? Nobody's in jail. And even if that weren't the case, let's say the FBI hadn't received documents and the SEC hadn't received documents related to GTII. What about Alpine? So Alpine, the SEC has been in litigation with Alpine, I don't know for how many years, even if they didn't want to know about GTII because of the allegations and connection between Alpine and GTII. How could the feds not know about GTII? Obviously, they know, and they knew. It would be like saying today that they didn't know about MMTLP after getting bombarded with information, interactions, etc. It's ludicrous. So why haven't they acted? Why? Makes no sense. Really, it does not. Not every decision or inaction should work to the detriment of retail shareholders. Sometimes we got to get a bone, buddies. And here you are. This is set up. This is like an easy one to me. This is like a slam dunk. According to the receiver, this is a slam dunk. So why aren't you after these guys like you should be? Or why are you being so slow? And where's the IRS if what the receiver says is true also? You know, shouldn't they be jumping after these people? Again, seems like a slam dunk, honestly. I'm not a prosecutor. I haven't seen all the evidence, all that stuff. But if you take the receiver's reports as true, then you know, I don't get it. So I don't understand why the feds have not intervened. In MMTLP, and this is not what I was going to talk about, MMTLP, they kind of took the opposite take. As opposed to staying away, they got involved. They did whatever they needed to do for their best interest to the detriment of retail shareholders. So in contrast to GTII, where the regulators are nowhere to be seen, but it's obvious and a slam dunk referenced by the receiver's reports, in MMTLP, they got involved in secret, at least it appears, or that was the attempt, although apparently from recent documents, perhaps they weren't successful in keeping all their interactions private. But it was the opposite. The regulators got involved, and the enforcement got involved to the detriment of retail. So, you know, it's tough to be to feel taken care of when it appears that the regulators and the ones who enforce the regulations will do anything to whatever angle they decide to pursue, it's to the detriment of retail. That doesn't seem fair. Again, I think bones should be thrown. I think, you know, GTI, MMTLP are two shareholder bases that deserve the bone. And MMTLP was first, obviously, and I was in that myself and am. But GTII, it's more, as opposed to the regulators here, it's just like the misconduct outlined by the receiver is public and has been public for quite some time, unlike the suppression that appeared in MMTLP. And I'll get to another thing about MMTLP at the end of this thing. Moving on, there's a hearing on the 14th. I've referenced it before. I filed a brief with the court. I talked about it in a prior live or tape, depending on when you saw it. And my brief outlined basically, I said, I'm a shareholder. Here are two issues that you probably need to address because they're important. One is the audit, and then I referenced that the order dated September of 2024, when the receiver was appointed. In that order, it said that the receiver, and this may not be 100% accurate, but pretty close, that the receiver was ready to take immediate corrective action with regard to filings, the OTC, etc., which suggested also by implication that the audit would be done on short order because you couldn't do the filings without the audit being completed. And as of now, we haven't seen any corrective action. And it's like 16 months have gone on. And part of the problem and part of the delay, as I outlined, was that so they chose prior management, which I guess another strike against them, chose Borgers as their CPA. Borgers got shut down by the SEC because they were committing fraud, it appears, in some fashion. Then they old management hired a firm, I think it was called Fortune, in Orange County, California. When the receiver was appointed, the receiver elected to stay with Fortune. They stayed with him for a few months. I think it was a mistake, by the way. I said at the time it was a mistake because that was the firm that was selected by the prior management. So why would you expect them to be helpful to new people? Because it might put them in a very questionable position. But the receiver or whoever elected to stay wasted time. Eventually, they terminated them, hired their own firm, and that's been going on for, I guess, a year without any reason for any delays, without any excuses, without any, any attempts to ascertain a date or to disclose a date. And no reason, at least the reason they give, I think, is not a real reason. Not a real reason there's no justification for not providing a date or asking when it's going to be done. That's different than asking for the substance. I'm not asking for the substance of what's in the audits. And again, I made the comparison to the crop report in Trading Places with Eddie Murphy, where they were going to get the orange crop report, and depending upon how it was, that would affect the price. We're not talking about content here. We're just talking about the date the report's going to be released and why it hasn't been released. And in my brief, I also asked that, and I mentioned this to Dylan, I have asked him multiple times to have some representative of the auditor to be there in person or available on the 14th. I see no reason why that shouldn't be done. The judge can inquire as to them, and I think it's a good suggestion, to be honest. The other issue I raised, and I passed that on to, that was filed in court, so the judge seems to read everything, so I assume he'll read it. I assume somebody will discuss it at the hearing. The second issue I raised was the compensation, and the biggest issue I raised, notwithstanding the amount and, that, etc., was that there's no restrictions on the sale of the receiver's shares, and that makes no sense. Obviously, the receiver should not be able to sell his shares before retail shareholders can. His selling shares could have a real detrimental effect on the value of shares because it will be a large block of shares. Anyway, insiders like him shouldn't be allowed to sell prior to real shareholders, like all of you out there. And that wasn't discussed in the order. I'm not blaming anybody, but it's not in the order, and it should be, because the receiver shouldn't certainly should not get priority over real shareholders. I believe there will be counsel on behalf of shareholders that participates in the hearing on 1/14th. It'll be a status conference. I think it's in the afternoon Pacific time, 1:30 p.m. I don't believe there's anything else on calendar, so however it takes, however it goes, that's how long it's going to go. But I believe that there has been counsel retained on behalf of the group of shareholders that speak with Oot, and I sent her a copy of my brief before she was hired, and I'm happy to provide her any background that she needs. So if she's out there, if you're watching, if you're a new subscriber out there, please like, subscribe, share, comment. And if you're a new counsel and you want to subscribe and you want to reach out to me, feel free, especially if you're a subscriber. But anyway, I provided her a copy of the brief, and we spoke once, and we may speak again, but I think she's going to be there on behalf of shareholders, since she knows that the audit is an issue and that the compensation is an issue. I would expect her to address both issues, and since I reference it in my brief, I would think makes sense that both issues will be addressed. I'd be surprised if they're not addressed. I think she knows all the players in there, and it's a case where I think retail will be represented directly at the hearing, which will be quite a thing. I cannot. It came up in a hearing. Now it was a little odd because it was the hearing where I became on my own, even though I was a plaintiff in that plaintiffs group. But I'm representing myself. But apparently, notwithstanding that I'm representing myself, I am restricted from talking. So I guess, unlike any other person who is representing themselves, I can't speak in court. I really don't understand why, but that is the ruling, and I'm honoring that ruling. But she would be representing a bunch of shareholders, and so it appears she would have standing to assert the position on behalf of shareholders. I have laid it out already, so at least it's on there, and I'm sure it will be referenced at the hearing by parties that might have a different opinion. But there will be somebody there that's kind of talking about on behalf of real shareholders, so that's good. And last but not least, I believe on the 12th of January, there is going to be a press conference or something like that in front of the SEC, brought by Anne and whoever else is involved, and that's to support and bring more attention to MMTLP. And again, MMTLP was a situation where some regulators and enforcement got together and stopped the trading, froze the trading of the stock before retail shareholders, or most retail shareholders, had a chance to dispose of their shares. So with no notice, and contrary to what had been disclosed before, there was supposed to be a date by which things would be over. At least a couple days prior to that, they pulled the plug. So everybody got stuck, and to this day haven't been able to liquidate their stock. And this was, again, by action, concerted action by regulators and those connected to the regulators to protect who, for the benefit of who, I don't know, but certainly for the detriment of retail. And to a large degree, they certainly weren't transparent afterwards. They have not been forthright in any respect. And unfortunately, to this point in time, there's been no action on, anywhere in DC to move this along to some kind of resolution. Hopefully that will, and hopefully this, I think it's a press conference. It's some event. Let's just say that. So stay tuned for MMTLP. Follow it. There's, those people they've hung in for a long time. So follow them, support them, just like you support Gtii. And that's all I have for tonight. Hope everybody is well. If I hear anything in the meantime, I will let you know. That was short and sweet. Everybody have a great night. Take care. Comment, like, and we'll see you soon. and be well.